Thank you, Visa, for the very generous introduction, and thanks to the team for putting together such a fantastic conference. I really can't wait to be done with this keynote so I can finally start listening to all the great speakers that you've invited over the next 2 days. Thank you very much. I'm just going to be using one of these then.
Yeah.
Excellent. So, I do have the great honor of talking to you today about my PhD book that, as Visa said, was written some time ago but only just published this year for reasons that we can chat about over drinks if you like. But here it is. This is the title of both the book and the presentation, More Equal Than Others, Humans and the Rights of Other Animals. If you want to help me turn this into a bestseller, you can get a copy at a discounted rate if you use the code AUFLY30, and you get at least 30% off if you use the OUP store. It won't work on Amazon or other places, but it will take down the price tag to a very affordable £63. Don't blame me for the high price. This is all set by the publisher, I'm afraid, so I didn't have a say in this at all. Okay, so what's the starting point of this research? It's the recent efforts that we're seeing around the world to have animals recognized as holders of fundamental rights or legal personhood. And I'll briefly mention 2 examples that you may be familiar with already. The first is the Happy case. As many of you will know, cases of this sort have been brought by the Non-Human Rights Project in the United States, among others. The Non-Human Rights Project is a civil rights organization that brings habeas corpus suits on behalf of animals, trying to argue that animals, or at least certain animals, are legal persons with an autonomy that should be protected and that they should be moved to a sanctuary where they can live freer lives. Now, in this case here, we're dealing with Happy, of course. Happy is an elephant who lives in the Bronx Zoo, or rather is kept there. And the Non-Human Rights Project was arguing that Happy should be moved from the zoo to a sanctuary. And a range of different courts in the state of New York had to deal with this case. And 2 years ago, the highest court in that state, the Court of Appeals, rendered its decision. And the majority held that no, Happy needs to stay in the zoo. And there were a couple of reasons that they adduced, but one of the arguments that seemed quite important in their thinking was an argument that was put forward by a range of scholars, really, but Richard Cupp, a scholar based at Pepperdine University, has been particularly prominent in emphasizing this point. And here's what Cupp says. He says that, well, the sky wouldn't fall immediately if courts started treating chimpanzees as persons. So he was still talking about the chimpanzee cases, but he was making the same arguments for Happy and the elephant cases. But over time, both the courts and society might be tempted not only to view the most intelligent animals more like we now view humans, but also to view the least intelligent humans more like we now view animals. So his worry, in other words, was that if we grant rights to chimpanzees, or Happy in this case, we might water down human rights. There's a slippery slope here that he's warning us about, and it seemed to have some purchase with the judges. This worry was also raised in other contexts, more legislation-based efforts to have animals recognized as rights holders. And I'll mention one example here, that of Switzerland, where a few years ago in the state of Basel City, a popular initiative, which is a sort of ballot initiative, was put forward by a group. I was involved in this group, helped draft the proposal to have the constitution amended so as to protect the right to life and bodily and mental integrity of all primates, so not just the human primates, but non-human ones too. As is the case with all these popular initiatives that are put to a vote by the citizens of the relevant state, the authorities, they basically send out a leaflet telling the citizens how they think they should vote, in this case, providing lots of information too. And they advise the citizens to reject the initiative. And among the reasons that they gave was this. They said, if fundamental rights were also granted to non-human primates, then this would blur the line between humans and animals, and our fundamental and human rights would be watered down and relativized. So again, we have the same worry here that it would undermine human rights if we granted animals some rights too. So this really was the starting point for me to think about, is there a way of extending rights and legal personhood, perhaps dignity? I'm using these terms rather sort of synonymously here. You can sort of fill in, but I'm mostly going to be talking about rights just for the sake of simplicity. Can we extend rights to animals without jeopardizing human rights? In other words, do we have an answer to CUP and the cantonal authorities and others who are worried about what granting rights to animals might do to human rights? So this is the question that the book addresses, and it's the question that we're going to be looking at together in this presentation today. Okay, so here are the different steps as to how we're going to tackle this. We'll start by looking into the history and specifically the a sort of relationship between human rights and animal rights that we can trace back to the French Enlightenment, really, and see what these debates can tell us. We'll then try to derive some conceptual lessons from this history, and I will make the case to you that there are broadly two different ways of conceptualizing fundamental rights that emerge from this history and that are still dominant today. One is what I call the aristocratic conception of fundamental rights, which is very dominant in human rights doctrine and practice. And the other one, which is prevalent in animal rights scholarship and activism, is what I call the meritocratic conception of fundamental rights. And we will contrast the two to sort of tease out the differences. And then lastly, we will ask whether there are some practical implications from all of this. And I will suggest that there certainly are, and I will argue that we should meritocratize the aristocracy. And I'll explain exactly what I mean by this term, which is a bit of a mouthful and will seem very obscure at this stage. And then lastly, I will tell you a bit more about an idea that I came up with, which I call the species membership approach, which roughly argues that rights should be granted to animals based on their species membership, not their individual capacities. So this is our plan for the next maybe 40 minutes or so. Okay, let's start with some history. There is a sort of commonplace notion, I think, at least among animal rights scholars, that modern animal rights thinking emerged roughly in the 20th century, specifically the sort of latter half. Tom Regan's The Case for Animal Rights, and if you want to be generous, you can maybe include Henry Stevens' Salt 1895, I think, argument for animal rights. But broadly, we're looking at the sort of 20th century, generously understood. But what I discovered in my research is that, in fact, animal rights proposals in the strict sense, so not just proposals for better animal protection or animal welfare, but proposals for fundamental rights for animals, they can be traced back to the Enlightenment, and I looked specifically at the French Enlightenment. So we're talking about the 18th century now, rather than the 20th century or late 19th century. And I'll say a bit more about this, but just to sort of perhaps flag here why I think this is really interesting. As some of you may know, human rights are generally traced back to the 18th century. So human rights are said to have emerged in the 18th century with the different Declaration of Rights that appeared at the time. There's some people who argue it came much later, but I don't find it particularly persuasive. I think the 18th century is a good place to locate the birth of human rights. And if animal rights were born at the same time, then something really interesting is possible now, and I think indeed it is true that they emerged in tandem with one another and to some extent in conversation with one another. So to really understand human rights, I think we also need to understand animal rights, and to really understand animal rights, we need to understand human rights and the reasons why they emerged at the time. So this is all still quite a bit abstract, so let's make it a bit more concrete by looking at two different texts that are representative of two different streams of thinking that became prominent at the time. We'll start with the first one here. This is a text by a writer, a philosophe, a French thinker at the time called Jean-Claude de la Métrie, who wrote this text, Principe de la philosophie naturelle. And he was representative of what I call a naturalist stream of thinking. So broadly, naturalists rejected supernatural explanations of the world. They started conducting experiments. They wanted to learn more about nature, and they started to see humanity as part of nature and to study humanity like they would study another animal. So humans are now part of a continuum of matter. Everything was seen as matter. This is materialism that many naturalists adopted. And this has important implications. Now, humanity isn't separate anymore from the rest of nature. They're part of it. They're part of the spectrum. And if you have a spectrum, you also have differences between different species and potentially also between different members of the same species. And we'll see later on how this can give rise to ideas of hierarchy, right, that you don't have in another way of thinking about humanity, which is dominant in our other writer that we're looking at briefly. So this is Jean-Baptiste Salaville, who read about de la Métrie's text, and he wasn't happy with it, because there was something really, for us, exciting that happened in the Principe de la philosophie naturelle. Not only did he take broadly naturalist lines of thinking, but he argued based on this that animals should have certain fundamental rights. He said, look, at the end of the day, animals are sentient, just like humans are. He called it sensitive. They're sensitive beings. And because they're sentient, they should have three fundamental rights: the right to life, the right to health, and the right to plaisir, as he called it, or sort of enjoyments. Now, this is quite striking. Again, these are proposals for fundamental rights, but Jean-Baptiste Salaville wasn't happy with this. He said this is very problematic. Like this guy, these naturalists, including him here, de la Métrie, they're doing something that's incredibly dangerous for humans. They purport to want to protect animals, but really what they do is they undermine the protection that humans have. And we'll see in a second what his argument for this was. But so as an egalitarian, he didn't think humanity should be seen as part of a sort of a continuum of matter. He thought humanity is separate from everything else. They're separate from all other animals, and all humans are equal. At least in theory, they should all be seen as equal, right? There's no gradations between human beings. They're all equal. And we should resist those naturalist arguments because they take us down a very dangerous road where we start to introduce distinctions between humans. Here's what he said. Salaville says, in trying to lift animals to the status of humans, humans are brought down to the status of animals. This doctrine, ostensibly human, is in fact full of injustice and inhumanity. Do you see the resemblance with what Richard Cupp is arguing, with what the cantonal authorities are arguing? I found it quite striking to read a text from a guy here writing in the early 19th century that is essentially making the same argument against animal rights that we are still seeing today being made against, cases brought by the Non-Human Rights Project. So basically what I did was I was like, okay, so how is it possible that thinkers that are more or less sort of 2.5 centuries apart from one another can take positions that are so similar with regard to both human and animal rights? De la Métrie is very similar to a sentience-based rights account a la Cochrane, for instance, that we're reading about today. So how is that so similar? And how is Salaville so similar to arguments against animal rights, a la Cupp? To answer this question, I tried to look at it conceptually. And what I did was I identified two ideal types. This is a sort of a Weberian methodology. Roughly, it's just the idea of there are different archetypes. We can see what's happening in practice, what different theories are doing, and we can sort of distill their essence and maybe take it to its logical conclusion, and then you arrive at an ideal type. So this is roughly the methodology that I'm using. And I'm saying, okay, there are two different things going on, two different ways of conceptualizing fundamental rights. We'll start by looking at the first one, which I call the aristocratic conception, which is the one that we can derive from Salaville's writings and those of modern-day human rights proponents. So the aristocratic conception is one that is not sort of universally accepted in human rights, but it is dominant, I think, in human rights thinking and practice. And I'll try to convince you that this is so. Because at first glance you might say, well, isn't human rights all about rejecting notions of, like, you know, small groups having special privileges? And yes, in some sense that's true, and historically that's been the development, but that's not to say that there isn't something in the logic of human rights that makes it quite an aristocratic concept. And here's why, and I'm not the first one to propose this. Jeremy Waldron, a sort of famous legal theorist based at the NYU, has made an argument along those lines in his Tanner lectures, where he says, if you look at it properly, you'll see that human rights really are about giving humans a high and equal rank, right? So all human beings have a special rank, a high rank. This is what human rights and, broadly speaking, dignity and equality are about. They are aristocratic ideas. They make a group special and they exclude others from it, as we will see in more detail in a second. And the aristocratic conception, as I alluded to a few minutes ago, follows this egalitarian stream of thinking that emerged in the French Enlightenment. And just as a reminder here, so egalitarianism, it's about saying that humans are separate from other animals and that they're all equal. All humans are equal. So you have equality and separateness. And this too is sort of reflected in human rights thinking. So I'll say a bit more about this just to try to get you on board with me. So the aristocratic conception I propose really has two main elements. The first element is what I call equal consideration. And equal consideration is nicely captured in Article 1 of the Universal Declaration of Human Rights. So this provision here tells us that all human beings are born free and equal in dignity and rights. There are three elements in here that I'd like to sort of distill with you. The first one is that all human beings are born free and equal. There's an idea of heredity here, right? We are born into this status, into rights holdership, just like noble people were born into their special privileges, right? We all have blue blood now, as far as our human rights are concerned. So it is something that we have simply in virtue of being human. You don't have to do anything to have your human rights. You have them just because you're born human, right? An aristocratic notion here. This is the first element, heredity. The second one is equality. All human beings are born free and equal. Again, there's no human being who has more dignity than another. There's no human being that has more rights than another. Now, here is an important place for me maybe to stop and say, this is in theory, of course. We're talking on paper. Of course, in practice, there are many human beings who don't have their human rights respected the way that others have them respected. But this is about the intellectual framework that underpins modern human rights thinking and hopefully to some extent practice too, right? So let's sort of accept this caveat. We're talking theory and on paper here. And then lastly, there's the element of exclusion or exclusivity. It says all human beings are born free and equal in dignity and rights. Implicit here, of course, is that if you're not a human being, then you're not born free and equal. And sorry, maybe you deserve some protection, but certainly you're not going to get the same equality and dignity and rights that human beings have, right? So in other words, animals are excluded from this, right? So if you go back to our, initial maybe a sort of worry about, are human rights really aristocratic or not? Well, as far as animals are concerned, it certainly seems like there's a special group with sort of special privileges, and animals are not part of it. They're the peasants, if you like, of the modern human rights world. Okay, so that's the element of equal consideration, which is what the aristocratic conception is about. But then there's also the question of how aristocrats, or this is a sort of people defending the aristocratic conception, I'll sometimes just call them aristocrats, how they justify this and explain why all humans are equal and have the same rights and are born into them. And I propose that they do so in an internalist way. What do I mean by internalism? Internalism is the idea that you start from normative propositions. You start from an ought. We think that humans ought to all have the same rank and rights, and therefore they do have the same rank and rights. So you start from something that's normative. It could be a story maybe that we're telling about why it's important, or it's a decision that we're making, but it is normative from the beginning. You don't try to trace it to something empirical. You don't say, oh, it's because we're intelligent. We sometimes tell these stories, but we're not actually really grounding rights in intelligence or autonomy or what have you, because we wouldn't say that an unintelligent human doesn't have the same human rights and equality, right? So we don't actually ground the rights in it. We'll come back to this notion because the meritocrats do just that. Let me use a scholar who's brilliant to illustrate some of this. This is Anne Phillips, who's a political theorist at the LSE and who is an aristocrat in sort of my book. And here's why she says we shouldn't do this grounding, this sort of connecting rights and equality to something like intelligence or autonomy. She says, if we link the entitlement to human rights to characteristics like vulnerability to pain or capacity for conscious planning or whatever other feature you may think of, the empirical evidence may lead to the conclusion that some humans who currently qualify for rights, say day-old infants who haven't yet developed consciousness, or those who are in a coma who've lost it, they wouldn't be entitled to the right because they lack the feature that sort of grounds that right or would ground that right. So we shouldn't go there. We shouldn't take that approach. We should instead be internalists. And what does that mean in her account? Here's what it means. She says we're not equal, or you can fill in here, we don't have rights or personhood because of certain facts about ourselves. Say because we have a soul, or because we're rational agents, or because we're vulnerable to pain. Though we may and often do articulate our claims in one or the other of these languages, as I said, sometimes talk about humans being intelligent and other things. She says, equality, or rights, is something we assert. It's something we assert, and to which we commit ourselves rather than something we find out. So it's not something we find out empirically by looking at studies as to human beings and it doesn't matter. We just claim that all humans are equal and have human rights. And that's it. That's what internalism is. I think the aristocratic conception has some real strengths. I don't think we should dismiss it so easily as I think animal rights proponents are sometimes want to do. Its virtue is that it doesn't make rights and status vulnerable to being challenged empirically, right? You cannot bring studies showing that, oh, I found that this group of human beings is actually less intelligent than this group of human beings, therefore they deserve fewer rights. You can't do that because human rights were never grounded in intelligence in the first place. They were always asserted or with something we commit ourselves to. And that, I think, is really important for especially human beings who are at risk of being marginalized or who are already marginalized and whose marginalization might be worsened if we went down that road. The aristocracy puts a stop to this, and that's a real asset in my view. But that asset also has a shortcoming, and really it's just the flip side of it. If you just assert rights or statuses, then you are at risk of creating quite arbitrary concepts and frameworks that may have very little connection to reality. And I think that's really what we're seeing now, where we are finding out so much about what non-human animals are capable of. And it seems increasingly arbitrary that there's this group, the human species, that has this very high rank and special privileges that none of these animals get to share. even though they would seem to have interests that are very similar to the human interests. So it's getting increasingly arbitrary, and that's a real problem for the theory, because why should you accept it if it's so arbitrary, if it's not a good fit with reality, right? And that's what we're testing things with at the end of the day. Let me now turn to the opposing ideal type, the opposing archetype of rights, which I call the meritocratic conception of fundamental rights. And I'll say a bit more later on about why I think they're really antithetical to one another. They're sort of mirror images of one another. But let's look at it in more detail now. So the meritocratic conception is the one that I said is quite prominent in animal rights scholarship and activism. So hopefully you will sort of see something that you recognize. And if not, tell me in the discussion. I'd be keen to hear. Again, not all animal rights scholars necessarily take this approach, of course, but it is a dominant one, I think. Just to give you one example here, the Non-Human Rights Project in one of its cases argued, for instance, that chimpanzees' autonomy and self-determination merit the right to be free from illegal detention. So what's happening here? What's the meritocratic conception about? The meritocratic conception doesn't say, oh, you're sort of born into a group and therefore you have a status. No. Meritocrats are looking at individual animals, and they're looking at whether they have capacities that they think make these animals deserve a given status or right. So in this case, the capacity for autonomy or self-determination makes the animal deserving of something like the right to bodily liberty and be granted the writ of habeas corpus and be moved to a sanctuary, right? So you're looking at individual animals and what they deserve. And this language of deserving and merit, I was actually struck by how common it is in the scholarship, because it is so natural to think of, oh, okay, so here's the science, here's what it's telling us about the capacities, therefore let's link it to rights, deserved. And this conception follows naturalism. So this takes us back to Jean-Claude de la Métrie, who was arguing that animals should have a right to health, life, and plaisir, because they're sentient. And the reason why his arguments, or the structure of his argument, was so similar to modern-day arguments in favor of animal rights is just they're following the same intellectual current, and it's naturalism. And that's why their arguments are so similar. But this is still a bit abstract, so let's look at the two elements that make up the meritocratic conception. And because these are antithetical conceptions, you'll see now that these features are actually also just the mirror image of the aristocratic conception. So instead of equal consideration, we now have differential consideration. What does this mean? So meritocrats reject this notion of heredity, that you have a right just because you're born into a given group, right? We reject this notion because we think it's speciesist, really, to think that, oh, this is just, you're born into this group and therefore you have the rights. No. Let's look at the given animal. Is it sentient? Do they have capacity X, Y, Z? If so, yes, okay, they may be deserving of certain protections, certain rights. So we're replacing heredity with merit. It's about individuals and what they deserve in virtue of their capacities. The next one, I think, is a bit surprising, but I do think it follows. We're also rejecting, if we're meritocrats, equality. And we're replacing it with something that I call gradualism. And here's why. If you think that rights are deserved because of certain capacities that are possessed. So let's take an example. Some people argue that the right to life is grounded in the capacity to plan for the future, maybe have a sense of the past, certainly not just live in the present. If you have that capacity to, plan for the future, then you deserve the right to life. If you don't have that capacity, you don't deserve the right to life. If you have it to a greater degree than another animal or human being, then you deserve that right to a greater extent than the other human or animal who has it to a lesser extent, right? So what's happening really is we're moving away from this idea of a sort of a whole sort of wholesale deal in human rights. You're human, therefore, in principle, you have all the human rights. You're moving to a much more gradual sort of retail approach where, depending on the capacities and the extent to which you have them and how strong your interests are, you get different rights and rights to a different extent. And that has implications, I think, important ones, because this means that we meritocrats, to the extent that we are meritocrats, allow for some beings to have stronger rights and more rights, and for other beings to have weaker rights and fewer rights. And this, by the way, applies to the human species too. If you find human beings who have more or stronger capacities and interests than others, then they deserve more and stronger rights than others, right? So you're looking at a hierarchization here, a gradualization. You're moving away from equality. That's a logical implication of the meritocratic way of thinking, or so I propose. And there's one more that I forgot, because it's an important one. You're no longer excluding beings that don't form part of the human species, of course, because we're now focusing on merit. If you're an animal that has the capacity for conscious sort of planning for the future, then you deserve the right to life. If you're an AI and have that capacity, then you might deserve the right to life. Beings are now included in the broad category of rights holders that were formerly excluded in the aristocratic conception. So we now have merit, we have gradualism, and we now have inclusivity. How do meritocrats explain all of this? They are externalists, so they reject internalism, they adopt externalism. And we've really already encountered it when we saw Anne Phillips's criticism of this idea of grounding, because meritocrats are all about grounding rights or statuses in empirical features, capacities, or interests. I don't think I'll have an example for this, but it's really quite simple, and we've been talking about it for the past sort of half hour or so. It's exactly what the Non-Human Rights Project is doing, for instance, when it's arguing, oh, there's an individual animal here who's autonomous, and therefore they deserve the right to bodily liberty. It's grounding that right in their capacity for autonomy. This is externalism. It's grounding. The meritocratic conception has a real strength. It provides us with a stable and non-arbitrary foundation for rights and statuses, right? Because we can say, look, there's the science telling us that these elephants have these capacities. Just yesterday I was reading an article in The Guardian actually saying that horses apparently too have the capacity for to plan for the future. So maybe the science is now telling us that they too deserve the right to life on that account, right? So we can use these studies. There's a solid basis here for rights that isn't arbitrary in the way that the aristocratic conception is. But that virtue has a downside too. And again, it's flip side. Because we are now at risk of potentially creating a hierarchy of rights holders, and we might endanger vulnerable humans for that gradualist reason that I pointed out, right? Meritocrats allow for more and stronger rights for some beings and weaker and fewer rights for others. This introduces the notion of a hierarchy, and it can be especially dangerous for vulnerable humans. And that's why Anne Phillips and others reject it so vehemently. I would now like to tell you what the practical lessons of this are. This may all sound quite theoretical and abstract and historical, but the history and the conceptual analysis that we looked at together tell us something quite practical, I think. The first thing that it tells us is, I think we should strive to achieve a practical middle ground between the two conceptions. Why do I say this? The two conceptions, as I suggested, are really opposites of one another. They are mirror images of one another. So this really means that if you move more in the meritocratic direction, say by becoming more of an internalist or adopting differential consideration to a greater extent, you're necessarily going to lose out on equal consideration and on internalism, right? And vice versa, the more you go in the other direction, you lose out on the positive things or the features of the other conception. There's a zero-sum game here. You could, in theory, try to construe an account that takes different features from different theories, but the method that I'm adopting here, the Weberian ideal type, recommends keeping them separate so that we can understand the tension better, and then as practical decision makers take the decision that we need to take, but being fully conscious of the different theoretical frameworks that are at play here without trying to sort of mask them or conflate them. So I think there's a reason here for just adopting that practical middle ground. And the middle ground, really, the reason for it is you want to take what's positive to as great an extent from both theories without incurring their deficiency. So trying to aim for a middle ground, but without confusing the two theories. If we agree that we should strive for that middle ground, we will find that at the moment, legal systems are much too aristocratic, right? So on this spectrum between aristocracy and meritocracy, we're not in the middle yet, we're very close to the aristocracy. So this is really why I say we should meritocratize the aristocracy, or just move towards that middle, in other words. How can you do that? I canvass a few different options in the book, and none of this will be particularly new, I think, to people in this room, because I'm just looking at options that other scholars have discussed and proposed. So two avenues that I look into are how we can change the property status of animals and some fundamental rights that could be given to them. So I won't rehearse this for too long, but just briefly, so on undoing the property status, obviously we're looking here at options such as maybe turning animals into living property, as David Faber has suggested. Potentially you could grant them something like sui generis personhood. Saskia Stucki, for instance, has made that argument. Or you could even look at maybe something along the lines of sort of natural human legal personhood, if that's where you wanted to go. I just look at it as sort of bouquet of sort of options. I don't sort of commit myself to any of these, but just looking at any of these options will take you closer to the middle ground. Same with certain fundamental rights that we could grant to animals. We've already mentioned a couple, but in the book I look specifically at the right to life, right to bodily and mental integrity too. Yeah, thanks, Visa. So these are some options that I look at. Now, what I'd like to tell you on the practical front too, before we wrap up this address, is what I call the species membership approach. And it seemed to me that there's potentially a danger here that if we're moving away from the aristocracy towards that middle ground, we might also overshoot the mark and go too far in the meritocratic direction and again incur some of the vices that the meritocracy has. So how can we avoid that? And a tool that I came up with is this idea that we should extend fundamental rights or legal personhood or dignity, take your pick, based on an animal's species membership, not their individual capacities. Now, at first glance, you might think that this is quite an unorthodox proposal because it smacks of speciesism, doesn't it? Our sort of alarm bells go off when we hear, oh, like group membership and therefore you have rights. Wait, this is problematic. Didn't Peter Singer tell us this? And I think if we look closely, it's not necessarily a problem. And the reason for it is that moral philosophy works by sort of different standards to law to some extent. So while it may very well be true that speciesism is problematic in moral philosophy and that moral rights shouldn't be extended based on group memberships, but rather on individual capacities and interests, law works differently. And I think part of what the book is trying to do is to say, wait, like we as lawyers, to the extent that you are lawyers in the room, should also emancipate ourselves from the philosophers. They're doing amazing work, and no offense to Rich and Angie specifically. They're doing amazing work, and I think we should build on this and incorporate it, but also realize that law has its independent standards and different ways in which it works. So let's take what's great about the philosophy, but let's not try to just copy-paste what philosophers are telling us, because law has its own different standards that it operates with. So what I suggest concretely is that we should extend fundamental rights and other legal entitlements, not moral entitlements, legal entitlements to animals based on their species membership, not their individual capacities. Why? I think there are good pragmatic and political reasons for this. The pragmatic ones are roughly as follows. If you're a judge and you're dealing with something like the Happy case, for instance, the judges in that case, as far as I know, weren't zoologists. They didn't know anything, probably, about what elephants are capable of, or not more than just the ordinary person would, right? So how exactly do they know whether elephants are autonomous, whether they have these relevant interests for the rights? They're unlikely to know that. But if you're operating on a species basis, if the judges know that all, say, Asian elephants are deserving of the right to bodily liberty, then it's easy for them to say, okay, well, I can at least identify this as an Asian elephant. This is pretty easy, right? So it makes it much easier for the judges who are not zoologists. They can identify so well what these animals are capable of. It'll also make it much quicker, of course, because they don't have to do that whole exercise of testing their capacities and interests. But the real selling point, I think, is the political one, because the species membership approach does two things. It allows us to extend fundamental rights or legal personhood to animals in the first place, right? Because the aristocracy doesn't allow you to do that, whereas the species membership approach does. It says you can extend rights and dignity and what have you to other animals if you want to do so. Just do it on a species basis. Why on a species basis? That's where the second political advantage comes in, because it doesn't risk undermining the rights of human beings, especially vulnerable human beings, who would be at risk of having that gradualism that we talked about applied against them and used against them, right? So if you're an individual human being, and that's what the judges are concerned about, if you're an individual human being who lacks autonomy, does Stephen Wise and the Non-Human Rights Project tell us that they shouldn't be legal persons? Surely that'd be very problematic, right? So they're very uncomfortable with focusing on individual capacities, and this approach allows them to circumvent that and stay on the species level, right? So that's why I think it's politically useful extending rights to animals whilst preserving the rights of human beings, especially vulnerable human beings. Let's wrap up now in the last 5 minutes by returning to our two case studies that we looked at the beginning. So what's the effect if we apply the species membership approach to some of the litigation-based efforts that we saw, specifically the Happy case, and then the legislation one in the Swiss case? So let's start with Happy. At first glance, I think it might seem that the SMA is problematic for litigation, because isn't litigation always about fighting for individual clients? So aren't you necessarily going to talk about their individual features and interests and capacities? That's certainly how it can go, but it doesn't have to go that way. And I think what the SMA tells us is that if you look at the Non-Human Rights Project's different arguments, there are some that are more problematic than others. The one that I do think is more problematic is what they call the autonomy argument, where it's all about looking at an individual and telling whether that individual has the relevant level of autonomy and therefore deserve the right to bodily liberty. I think that's a problematic argument for the reasons we discussed. But they also have other arguments that they bring, the equality argument, for instance, where they say, look, it's accepted that there are human beings who have legal personhood and are sort of beneficiaries of habeas corpus despite potentially lacking autonomy. And still they're getting these protections, so why not extend them to animals? To my mind, that's the much better way to go, because you're no longer looking at the individual capacities of animals and humans. So there are species-based arguments or group-based arguments more broadly that animal rights activists and litigators can make that are less at risk of running into those meritocratic problems that potentially jeopardize some human rights. What about legislation-based efforts? We looked at the Swiss case in Basel City. I think just by virtue of how legislation works, being more general, it's a bit easier, and we'll see easily how it doesn't really run into the problems of the meritocracy. in the Swiss case, for instance, the proposal was to have all primates recognized as holders of the right to life and bodily and mental integrity, right? So this is a biological order, but you say it includes all the different primate species, of course. So it is a group-based approach that doesn't run into that risk of focusing on individual capacity. So I don't think actually most, at least the ones that I can think of, legislation-based proposals are going to run into those problems of undermining human rights for the reasons that Cup and others point out. Now, I grant that there are other ways in which human rights and animal rights can potentially sort of come in tension with one another. If we grant rights to animals, they're going to conflict with human rights at one point or another, and they're going to have to be resolved, these conflicts, using proportionality or whatever other means. There's also the question of what do you do with scarce resources, right? How do you distribute those resources when it comes to actually enforcing rights? These are issues where the two can come into conflict, but what I try to do in the book is by focusing on the question of distribution to show how there is at least a way, the SMA being one option here, of extending rights to animals without jeopardizing human rights in the way that some human rights proponents are concerned about. So I'll end here. I'll thank you for your attention, and I look forward to the discussion. Thank you.